Also, we had some issues, didn't we, on the monitor?
There
Or is it,
there
was,
was a charging issue at one time, but the court removed the monitor.
the monitor was for what purpose? There,
I don't know. That's
we
why.
had monitors for everything.
Right. That's why I filed a motion to remove it because I didn't know
Was
what
it-
it was for.
It was just GPS,
GPS monitor?
I think, or something, you know.
Okay.
But the court removed that.
Really probably need more in the way of drug patch.
We had the drug patch.
Does he still have that? No, he's been in
No,
custody.
no.
But I mean, was that a condition of bond?
At one time, but no, it was no longer a condition of bond at the time, but he was here the other day.
Sir, you're gonna have to change your clothes, or what are you here for? For what court? For this court, for what? No, when that is, gets everybody's attention, which it does, this is a court of honor. You're supposed to have decent, would you wear that to church? Now, we're not church, but it has the same respect. Get another shirt before you can come back in here. I don't want you to have that shirt that's got writing on it and it gets people's attention. Dress nicely, please.
Good, step outside.
You're excused.
Step outside.
Thank you, sir.
What are they doing? Step outside, sir.
It's not a debate, sir. Thank you. Just dress nicely. That's not hard to figure out. All right. Okay, go ahead.
Well, Judge,
What do you want?
well, if I skip most of the contents of the motion, skip most of the grounds, and I go back to what we're
Whatever's
asking for,
substantive, yeah.
what we're asking
you
for
want.
is the court to reinstate the original bond.
Why? Okay, tell me about why there's not a punitive measure that should be placed because of the positive test for marijuana.
Okay, well, Mr. Kolar has a prescription for medical marijuana in the state of Louisiana. Louisiana has comprehensive state authorized medical marijuana programs. Louisiana revised statutes 40.1046. I cited it in the statute. It permits physicians to recommend medical marijuana and they can buy it through the state department through the dispensary. Texas also has a very similar program. It's called the Texas Compassionate Use Program. It authorizes physicians to prescribe THC cannabis to patients as well. Those programs may be independent, but the federal government now recognizes both of those programs. Last week, the federal government rescheduled marijuana, scheduled at Schedule 3, which does allow it to be prescribed. And it also states in that rescheduling Schedule 3 that it recognizes all state medical marijuana programs. So I believe when the court asked me the other day, does Texas recognize Louisiana's medical marijuana program? My response would be under the Commerce Clause.
They may
yes,
very well.
the federal
They may
government
very well.
recognizes all medical marijuana
My
programs.
issue is what restricts this court from ordering a condition of bond to prevent him from using THC, a controlled substance? Why can't the court have the power to do that, notwithstanding the law that says he can have medical? It doesn't say that a court does not have the authority to make its own rules of bond restrictions, such as restricting controlled substance use, which I intend to do at all times.
The first reason, Judge, is because this court has made no individualized findings to this particular defendant why that condition is appropriate.
It's appropriate for all.
If
See,
we'll
when
go
I
back
said
to
it,
my,
it's
I'm sorry, I
appropriate
was
for all.
making my argument. You asked me to make my argument. I was trying to do something. If you look at
And
section
thank
3.
you for interrupting. Thank you for go forward.
If you look at section 3, that talks about how there is actually now legal hemp marijuana in all states. The federal government also recognizes that. If a person uses that, they will also fail for marijuana. But you're referring to the condition that the court has on the general order. Well, it's on the court's website, which basically states that no person who's charged with a crime in Jefferson County District Court is allowed to use any marijuana products of any kind for any reason, at least without prior court approval. Now, there's a lot of problems with that. Number one of the problems with that is that it's a blanket condition that's not authorized by any statute. It's unconstitutional because it's a preset bond that imposes a condition without any individual findings on all the defendants charged in this court. There's a federal case that came out in the last 10 years, which was O'Donnell v. Harris County in the Fifth Circuit, which was all about preset bonds that did not consider individualized determinations regarding the amounts of the bonds.
I'm
And
familiar with that. All cases should be individualized.
correct.
You know,
So a general
Tell
order,
me that.
so a general order that has a condition that's not authorized by statute is a condition that is not individualized to each defendant that it's being applied to. So it was never individualized to this particular defendant that I'm aware of. I don't believe there are any findings made particularly on the record for this particular defendant. So that's a preset bond condition without any individualized finding to any particular
Are you
defendant.
saying all of our general preset bond conditions are unconstitutional?
Oh, no.
Because they're in every case.
Oh, no, they're
But
absolutely
they
not.
are in every case.
They're all statutory authorized, Judge. The safety, no communication with the victim is statutory authorized. Do not break a law is statutory authorized.
Yeah.
Travel restrictions, statutory authorized. Those are all statutory authorized. There is no statutory authorization for a blanket, no legal substance
What else?
usage in this county. There is no condition in Jefferson County State. You cannot use alcohol as a condition of a bond. The reason is because it's not statutorily authorized,
No.
and it would not be an individualized finding made.
Is marijuana still a controlled substance in this
It
state?
is a prescribable substance
Is
by a
it?
doctor.
I'm asking you.
Yes,
It's not.
of course it is.
Okay.
Yeah,
All
of
right.
course it is. And I don't believe there's a condition right now that states that all prescriptions must be turned into the court. All controlled substances must be pre-approved by the court before getting a prescription. It appears to me the only one is marijuana, and I haven't figured out why marijuana is being singled out different.
It's not being singled
Other
out.
controlled
It's just
substance.
a subject of this issue right now. When I deal with issues when they come up, sir. And this one has come up, and this is a kind of a first review of such an issue ever brought up in the 20 years that I've been doing this. So, and I'm not surprised. Things are always new here, and so I haven't. We just don't come here knowing all the history of what circumstances can be, because every day we see a new set of circumstances. This court has a consistent decision that it has always made on controlled substances, and controlled substances when it comes to marijuana. This court has an issue when you are able without any restrictions use a controlled substance to drive a 4,000-pound missile around town, or to function in ways in the free world that require thinking outside of a controlled substance, then the court's going to deal with those issues individually. And a lot of people have prescriptions. Those are controlled substances. That doesn't mean that they can't use that controlled substance. This court is not satisfied that in this particular case, this is an issue that is, nobody's told me, nobody's convinced me that it's necessary for whatever his needs are, and that his needs of marijuana do not adversely affect the general public in his daily functions. And that's what this is all about, is the welfare of everybody else, as well as his rights. But yeah, I open the door, and then somebody comes along, and what's good for one is good for everyone. And this court has not been convinced that this is necessary for whatever his needs are, notwithstanding a prescription that may have been submitted to him. And I'm more concerned about the well-being of the general public when people are able to get in a 4,000-pound missile and operate a missile while under, let's see, while under the influence of tetrahydrocannabinol of marijuana. That's the issue. Anything else?
Yes, Judge.
Let's go. I've got to
So-
get back to a trial.
So, Judge, part of the other problem with that standing order right now, not only is it not individual findings
It's a
made-
standing order for him right now under his circumstance.
Right.
There,
But-
you won't find it written anywhere. When you call it a standing order, let me correct you, please. It's not standing. You're not going to find it anywhere.
It's in the
But under
general
his
user.
circumstances, under this circumstance, which is really kind of a first impression for the court, that's what I did.
Judge,
Go
General
forward.
Order number 2023-1 is on the court's website as a standard general order applying to all defendants. So
Okay, read it
is-
out loud.
Read the general order out loud?
Yeah.
Okay, well,
What is, do you have it?
yeah, I mean, I cited it right here in my motion. It says right here, the one I'm particularly talking about, it says that no defendant shall use any amount of form of tetrahydrocannabinol, including but not limited to marijuana, hemp, delta 8 THC, delta 9 THC, delta 10 THC, THCV, THC-O, CBD products, synthetic cannabinoids, or any other products or substances that contain or derives any amount of form of THC, unless a valid and verifiable medical prescription is provided and approved by the court. Problem is that by requiring a person to provide medical prescriptions to the court without any individual findings of why that particular person needs to do that, number one, that's a violation of HIPAA. Your court is requiring people to disclose their medical conditions to the court before any findings been made that is somehow relevant to their case. He's going to have to provide who his physician is, the treatment status, his medical condition, the medical treatment plan. All of this is in violation of HIPAA and his privacy
Whatever.
rights if there
I
have been no
understand.
findings
Put that
made.
in there. What else?
The other thing I'd like to point out is that the condition, even though it's actually never been applied to him individualized, there's no purpose for that particular bond in this particular case. His case doesn't have anything to do with drugs. His case, he's not been alleged to have been driving on THC. He's not been alleged to have been intoxicated at any point in time in this particular court. The metabolites in his urine will show the marijuana for up to 30 days. He's prescribed marijuana. That's to be expected. So, Judge, what I'm requesting from the court, and Judge, I do need to get the court the prescription. The state's got it. The court's got it. I don't have a copy of it in my hand. And I'm going to have to update the court with a business records affidavit because the pharmacy in Louisiana has not yet sent the business record affidavit for admissibility purpose. But I will make it for appellate purposes, make sure I get that to the court. But what we're asking the court is to declare that the blanket THC condition on the general order as applied to all defendants is unconstitutional. It's not statutorily authorized. To remove the THC prohibition from this particular defendant's conditions, because there's been no individual findings that condition applies to him. Remove.
You've stated that. You've stated that. What else what other relief are you asking?
I'm asking the court to reinstate the original bond amount because the revocation of his bond there's no violation that's been alleged or proven here. The drug test doesn't prove any actual violation. He hasn't broken any laws. He's followed all of the laws, including federal law. And so we're asking the court to release him immediately.
Wait. Once again, he tested positive for having THC in his system.
We know that.
Okay, that's a controlled substance.
Is a prescription.
Oh, okay. What does state say?
Judge, the thing that's not been shown is that Texas has a reciprocity statute that says we recognize the medical marijuana card from Louisiana. Plus, the other thing I see on the bond conditions are that there is a way if he has a prescription, but it's got to be approved by the court. And that should have been done a long time ago before he tests positive. Then you come up and start screaming foul. Somebody should have come and said, hey, we've got this, and this is going to be a possibility if he tests. And so we need to get approval by the court, and we should have the medical record showing what condition it was, and that it meets our statute under Texas statute for medical marijuana cards. Or he could come to Texas and get something here, but he has to be a citizen to do that. So in order to do that, he'd still have to show that he's in compliance with ours for us to even consider whether we're doing reciprocity, because I don't know what his condition is. We haven't heard anything about why he's taking it, other than he's got a medical marijuana card.
You would have to move here, though.
Anything else? I've got to move forward. Anything else you want to add on?
No, just that we'll have to supplement the record at a later time with some additional.
You're allowed to do that anytime, whatever supplementation you need. See, he's asking, hold on, Mike, he's asking for reduction. What do you say on a reduction of the $100,000 amount? What was the original amount?
16.
I'm sorry?
16,000.
Judge, we're still gonna have the same problem next time he comes in, so
How long have you been in jail?
Since
No.
he's got the car.
I don't have a problem with some relief on the reduction.
What was your original bond?
16.
16?
16,000, Judge.
That's all.
Yeah, we're all number, huh?
Okay. The court is going to grant the relief that's requested to back to 16, but the court is going to, everyone is going to test you, and I'm going to continue, we're going to get the circle back. You're going to have a drug patch. You're going to have a drug test
Yeah.
as a condition of your bond. You test positive, we're going to come back here. I agree, the state,
All the other family.
I agree until, I'm not gonna follow Louisiana law and the Napoleonic, based upon the Napoleonic Code. They have the right to conduct their business in that state. This state, no, until this court, these laws from this state that give the relief that where you can test positive for THC and without other restrictions to ensure the safety of the community, because THC is illegal. And that does not make the world a safer place when you're able to operate a 4,000-pound missile around town and do heavy construction or whatever it is you do. So you test positive, we're going to come back here and we're going to have another hearing. And until this court can get a finding from a court of higher authority in this state that medical THC allows you the freedoms that everybody else has using THC, this court is not going to put people in. So be careful. And they'll be tested, and if it's positive, come back up and we'll have to do another bond issue. Anything else? Here's this. Thank you. All right, let's get ready for trial, everybody. And again, this is